Hi Cyberclass, it's Professor Opterbeck. I wanted to give you a little bit more supplemental background on the Carpenter case and as well on some of the statutes that we're starting to look at this week. And one of the difficulties here is that Carpenter falls in this kind of long line of cases or perhaps modifies this long line of cases in criminal procedure in the Fourth Amendment context regarding reasonable expectation of privacy and really what we can say are new kinds of technologies. We get into this in more depth in information privacy law class, which I just taught this part of this class. But I wanted to give you this background because we're going to be touching on some of this and getting into some of these statutes a bit more in this class. So what's useful here is to look at the history of the interpretation by the Supreme Court of the Fourth Amendment in relation to new technologies. And remember that all of these cases that are on the screen here, including Carpenter, are cases in which the government has acted without having a search warrant. If the government gets a search warrant, then we're not asking these questions in the same way anymore. Now, there may be cases in which a defendant argues that a warrant was improvidently granted, but the gold standard is you go get a warrant, and then usually that's gonna satisfy the Fourth Amendment. Now, I mean, a lot of times the questions about a warrant, is the warrant too broad? We still have many of those questions, and some of that I talk about in my Law Enforcement in the Cloud article that I also asked you to look at this week. But initially we want to talk about, is there a reasonable search and seizure absent a warrant? So we have Olmsted, 1928, talking about wiretaps. And notice that this is in the age of long distance telephone. You're literally putting a tap on the telephone line. And holding that a warrant was not required for a wiretap. Now hold that for a minute, because you're probably thinking, wait a minute, I thought wiretaps are illegal without some special process. You're right, that's a matter of statute. So we're going to look in a second about how how Congress has intervened in some of these places. And one theme is kind of the relationship between the Supreme Court's interpretation of the Fourth Amendment and Congress. In 1961, we have the Silverman case, which involves something called a spike mic. If you can see this picture, it's a microphone that is placed into the wall. So it can be placed into an external wall, but in some sense it's protruding into the physical space. And there the court said, no, you'd need a warrant to use that kind of technology. Lopez, 1963, we have the wearing of an undercover wire. So this, you watch a show about the mafia or something, there's always a character, right, who's wearing a wire in the coat, and that's the technology we're talking about. And the court said, no, you don't need a warrant for that. Katz in 1967 involved putting a device on the top of a public telephone booth. Now, of course, right, this is a different technological age. We don't really use telephone booths anymore because we have cell phones, but this is a period of time before cell phones, and if you were wanting to make a call outside of your home, you might go in a telephone booth. In this case, it was a guy who was running an illegal gambling scheme, and he would place phone calls from the phone booth, and the court held that there was some reasonable expectation of privacy in a phone booth because you're closing the door and you're the only person in the phone booth. And in fact, it's in Katz that actually in a concurring opinion in Katz, but it later gets taken up by the court as what becomes the reasonable expectation of privacy two-part test. So the person has an actual subjective expectation of privacy, and it's an expectation objectively that society would be prepared to recognize. And as this test gets developed in other cases, part of the balance is it can't be an expectation of privacy that only a criminal would have. Nevertheless, it might protect some criminal activity. Now, one of the interesting doctrinal questions as we read Carpenter, and as you look at the different opinions in Carpenter, is really kind of the status of this reasonable expectation of privacy test. And I'll suggest that Justice Roberts' majority opinion in Carpenter is typical of Justice Roberts, a kind of way of cobbling together a coalition that is sort of neither exactly affirming the precedent nor disavowing the precedent. When you look at some of the other opinions by some of the other originalist justices, some of them are wanting to really suggest that reasonable expectation of privacy is a judicially made up test, that the text of the Fourth Amendment is actually about property rights. And in that sense, the Fourth Amendment could be read a lot more narrowly than a reasonable expectation of privacy because it's about property rights. Although, when you look at Justice Gorsuch's opinion and his idea about the bailment of personal property, including perhaps personally identifying information, if that is in fact some kind of property right, it might be broader. So it raises a bunch of interesting questions about, Carpenter does, among other things, about the status of the reasonable expectation of privacy test. All right, so then 1971 in White involves a radio transmission to a confidential informant. Smith, 1979, involves a pen register. Now, we're going to get into this a little more in a few weeks, but a pen register is a device that can record the phone numbers that are called from a telephone, and a trap and trace is a device that can record the numbers coming into a telephone. Notice that this is older technology. It's again for landline telephones. But the court said that a pen registered device does not require a warrant and articulated there what has come to be known as the third party doctrine. And again, this is important for Carpenter. The idea of the third party doctrine is that you don't have, right, a reasonable expectation of privacy in information that you disclose to a third party. In White, we see a confidential informant, even if it's someone you trust, even if it's someone who you think is part of your scheme but really isn't, you can't be sure that person isn't going to turn the information over. So, with some exceptions, there are privileges like attorney-client privilege and so on to some extent. But this broad doctrine would suggest, well, if I turn something over, and that includes, right, turning over information to a phone company about phone numbers I'm dialing out, because the phone company uses that information to track your calls, or in our more modern context, to my cellular provider, when my phone is constantly pinging the cell tower saying, here I am, here I am, here I am, right? So it's ready. The argument of the government really was, well, the third party doctrine says you've given that information over to the phone company. And that's, part of that debate in Carpenter is saying, well, does the third party doctrine even really exist anymore? Or does it apply? Right, that's part of that. All right, Kylo 2001 involved the thermal scan of a home. So this is using a thermal scanner. The police are staking out across the street. And in that particular case, we're finding that the person was using grow lights to illegally grow marijuana plants. So in Kylo, one of the interesting things for today is the court is suggesting that, a thermal scanner is not an ordinary piece of equipment. Most people don't have access to it. And the government was arguing, well, we're only taking information off the wall, right, as it comes out. And the defense was arguing, no, you're actually peering into the home, right? And into the home, the space of the home is really a traditional zone of privacy. And the court did not buy the government's argument. By the way, these are coded. So, red, the court held that the government needs a warrant. Green means the search can happen without a warrant. Now, an interesting thing with Kylo is those devices, right, those thermal scanners, actually now are pretty common. And, there's consumer grade, relatively cheap devices you can get. All right. Jones involved in 2012 involved a device called a Stingray, a GPS tracker that's attached to a car. And you can see we're getting into this era of kind of location information. Now, even though the car is in a public place, right, and you can observe the movements of a car, the court said there is something about an individual's car that has some sense of privacy, and you wouldn't expect someone to surreptitiously put a tracker on the car. All right, and then we have Carpenter, which is historic cell site location information. So just to get a feel, right, for a bit of the ebb and flow, and then, statutory, Congress has intervened in response to some of these cases. Back in 1934, part of the Federal Communications Act of 1934 included a wiretap provision that limited wiretaps. It was a relatively weak provision, but it was there. 1968, it was called Title III, or later called the Wiretap Act, strengthened those protections. We're going to talk more about those in a couple weeks, but it basically requires a super warrant. It requires probable cause plus an additional showing that usual investigative measures are not sufficient and/or there's some danger to police. And then in 1986, there's a package of legislation that we're peeking at today: the Electronic Communications Privacy Act, the Stored Communications Act, the Pen Register, and Enhanced Wiretap Act. And you can see all of these things now are starting to get into the digital era, right? It's still 1986, still pre-modern internet era, and we'll see as we talk about them that these statutes really also reflect an older kind of technology, but they provide, now as the wiretap statute requires a super warrant, the ECPA and the SCA and the Pen Register statute actually allow the government to get certain kinds of information based on a court order short of a warrant, well short of a warrant. And in fact, Carpenter, as you read that case, the government actually used an ECPA order to get that historic CSLI. So it's not that there was no court intervention, no role for judicial oversight, but it's a showing much less than probable cause. And so really the question is just, can it be this lower showing of just some necessity, or does it have to be the higher showing of probable cause? And then CALEA 1994 is a statute that requires telecommunications providers to provide a certain kinds of assistance to law enforcement. Now, when you hear that one, you will think maybe of the Apple versus FBI dispute from a number of years ago. And one of the twists of that case is Apple is not a telecommunications provider as defined in CALEA. And so one of the questions that got a little bit lost, I think, in the fog of the Apple FBI case was whether, in fact, CALEA should be updated to include providers such as Apple. The Apple v. FBI debate, by the way, has other precedents in discussions of the Clipper chip, which also goes back to the Telecommunications Act of 1996, and then continuing noise here and there. It still comes up about the possibility of criminals going dark, right, of using encryption to stay off the radar screen, so to speak. And that's part of what I get at, and you see my effort to kind of split that baby in my law enforcement in the cloud paper. And then we continue to have these discussions about GPS tracking technology, about the use of predictive analytics, video analytics, facial recognition, a whole bunch of other things. And we'll come to some of this next week in the more international context when we look at the FISA statute and the post 9/11 surveillance, and then we'll come back and tie some of these loops together. But I wanted you to have a little bit more of an overview as you look at the stuff for this week and as we have our discussion about Carpenter.